Hey, hello, everybody, and welcome to JCPC Watch, coverage and analysis of the Judicial Committee of the Privy Council, the least covered, most important court in the world. This is our very first episode, so thank you for watching or listening. My name is Mark Russell, and I'm joined by my co-host, Rupert Wheeler. Rupert, how are you?
I'm very good, Mark. How you doing?
I'm all right. This is we're gonna see how this goes on our first go round here.
Yeah,
And
I'm very excited. I think it's going to be a lot of fun, and maybe we'll learn something as well. You never know.
That would be great, wouldn't it? I always find I learn things when I started really digging into the Privy Council uh, judgments, because it's just jurisdictions from all over the place that have sometimes very interesting and bespoke and esoteric statutory or constitutional provisions that come up and that find their way into up through the appellate system and find their way up to the Privy Council. We're going to talk about some of them. So what this is all about is just that: is exploring the jurisprudence and recent cases and developments at the Privy Council. And what we're going to do today is kind of quickly round up some recent judgments, and then we're going to have a deeper dive into two recent decisions: the Jardine Strategic Limited and Oasis Investments 2 Master Fund Limited number 2 about the shareholder rule for privilege, and then Anglin against the governor of the Cayman Islands, which, Rupert, you were involved in.
I was indeed. I was indeed. So yeah, interesting constitutional case on the Cayman relationship with the UK. Not one that we were successful at any level, I should add, but nevertheless one that I think is important for all sorts of reasons, as we'll get into a bit later on.
Yeah, well, we'll get to it. But first, Rupert, have you ever been on a podcast before?
You know what? I don't think I have.
I
I think this is my first podcast. Yeah. How about you?
I haven't either. About 20 years ago, I was on the radio. But that's I think that's the only time I've ever been in any kind of media like that. Oh no, that's not true. That's not true. I should back myself up. I was once interviewed on the CBC in the Newfoundland Cricket League finals.
Oh yeah, very good.
Yeah.
Were you playing?
I was playing. I was playing. They
Right,
also
okay.
yeah, I was
I was joking.
yeah. Yeah, well, it's quite interesting. I think they were just interested that a local was there, playing with a lot of South Asian immigrants.
Right, yeah,
Yeah,
yeah.
I was yeah, yeah. So, an interesting one indeed. So look, let's jump right into it. That's enough small talk. Let's give the people what they came for here,
Well,
which is Privy Council action. So let's just go through just some recent judgments, just to touch on these, what the Privy Council's been up to. Obviously, over the summer break, what you just get is kind of the steady drip drab of judgments coming out as they're getting finalized and handed down. No real hearings happening, except dealing with some permission to appeal applications along the way. But a lot of paperwork still gets done, even between terms. In the month of August was a fairly busy one for judgment hand downs. It started with the aforementioned Jardine Strategic Limited and Oasis Investments 2 Master Fund. There were two judgments. We're going to talk about the second one a little while later, but the first judgment was on a different issue, and it was a merger appraisal dispute, which has been quite an industry in several offshore jurisdictions, including Cayman and Bermuda, over the last number of years. Where if a when you have typically it's a going private merger transaction, and shareholders who are having their shares canceled or purchased for value can dissent from the merger if they don't like the value that they're being offered, and they can go to the court and have the court determine what the fair value of those shares are, and what they should have been paid. And this presents effectively a arbitrage opportunity for investment funds, which has driven a lot of these disputes. I would say the vast majority of these disputes are driven by investment funds that pursue this as an investment opportunity when they think that the merger price is less than what the fair value is, and that they can get a better return by acquiring those shares, dissenting from the merger, bringing the court application, and either reaching a settlement or getting the decision from the court. as to what it is. And as we're both aware, Rupert, from our work in Cayman,
Yeah.
these are massive industries and massive files that people do. The issue here, and this was a case from Bermuda, was, can a shareholder who acquired their shares after the merger has been announced apply as a dissenting shareholder? So, in other words, is that merger arbitrage opportunity available? The board, in a not a super long judgment, held that the shareholders of record at the date of the meeting have the standing to apply, so that that arbitrage opportunity still does exist, and that's in line with what the vast majority of other jurisdictions that the Privy Council went through, including the Cayman Islands, has found as well. So these type of challenges haven't really been successful under the Cayman legislation. This Bermuda one found its way to the Privy Council, which did canvass a lot of other jurisdictions from which these merger appraisal provisions come from originally, and found their way
Yeah.
there. We also had a case from Mauritius, which, one of the shortest Privy Council judgments I've ever seen. It was 8 pages, 3 of which were, the cover page, the appearance page. But this was Danu and
Double spaced as
Jacori.
well.
Yeah, it was a landlord and tenant dispute about the fair market value of a lease. And the Mauritius law on this only allowed appeals on points of law. The decision below was clearly simply based on the evidence that was before the original tribunal. The board quickly dismissed it.
Yeah, this is the sort of appeal I imagine that they were trying to head off early on with the proposed rules in relation to appeals that are devoid of merit. I'm not sure that those, I mean, they don't quite apply to these circumstances, but I imagine that the board get fairly sick of these sorts of appeals coming through where they simply don't have any prospects of success at all.
Yeah, but they have a right to appeal
Yeah,
under their domestic law or whatever instrument
yeah,
gives you the your access to the Privy Council. So they
yeah.
find their way there. This was one where they actually had 3 judges under the version of the rules that was ultimately implemented, that they only assigned 3 members of the panel, to the panel on this one. So, it kind
Which
of
doesn't look
which
good.
doesn't look good. I think if you're checking your schedule, on the on the Privy Council for your
Yeah,
case and you're only assigned it to 3, you can probably rest assured that your appeal is going to be dismissed.
yeah. You can book the early train out of London, I think. You won't be staying overnight.
The other case we have was Gift and Rowley from Trinidad and Tobago. This was again a very kind of technical appellate type of decision, where the issue was, did the Court of Appeal go too far in overturning factual findings that were made by the trial judge? The underlying dispute was about how much land was subject to an agreement of purchase and sale, which shows the kind of variety of cases that come up to the Privy Council. The Court of Appeal had found that the judge was plainly wrong in some very central fact findings, which is normally the standard for an appellate court to interfere
Mhm.
with the factual findings of the trial judge. The Privy Council, however, said the Court of Appeal really overstepped its role and started to veer into credibility and reliability analysis rather than just the gut check of whether a trial judge was
Yeah,
palpably or overridingly wrong on their factual analysis. So
yeah,
again, it's like the Lord Justice Lewison statement of the trial is the trial isn't the dress rehearsal. It's the first and the last lane of the show. So don't be
yeah.
bringing your fact finding issues back up to appeal courts. It's not their role.
No, absolutely.
Then we had Antigua and Barbuda Transport Board against Cardi. As you would expect, this one came from Antigua and Barbuda. It was an unfair dismissal claim at the industrial court. The unfair dismissal had been found to be harsh and oppressive, and so they awarded exemplary damages. The Court of Appeal set those aside, saying that the industrial court hadn't made the necessary factual findings to justify exemplary damages under the common law test. But at the Privy Council, the board found that the relevant statute contained a wide discretion for the industrial court to award damages, including exemplary damages, unconstrained by the common law rules. So maybe a decision that is limited in its interest to Antigua and Barbuda, but I think the general message is, the statutes. You have to look at your statute, and you can't always assume that common law principles are just going to be imported into the statutory interpretation.
Yeah, no, really important.
And then finally, maybe one we'll talk about in the future, but featured you, Rupert, at the Privy Council, the Attorney General of the Cayman Islands against Bush, very briefly, because I know it's not completely concluded on your end, so we won't put you in any kind of a position to have to talk about it. But the board upheld the Court of Appeal decision that the appellant's constitutional rights were not infringed by her inability to bring an unfair dismissal claim under the Cayman Islands Labor Act, which on its face explicitly does not apply to employers who are charitable organizations, which was the employer of the appellant there. So that may be one that we revisit in the future on another episode to talk about, if you're up to talking about your experience actually on your feet in front of the board.
Oh yeah, absolutely. Um, One of the most difficult few hours of my life, probably, but a fascinating one. And yeah, I'd be more than happy to discuss it when matters are
Yeah, I
finalized for
think
sure.
we'll definitely return to that one. Well, look, that's the roundup. Let's talk about the two cases that we're really here to dig into today. And the first is, as I say, it's that Jardine Strategic Limited and Oasis Investments 2 Master Fund Limited. And this is the judgment number two, the second of two judgments that the Privy Council promulgated on this one. And this one is about the shareholder rule. Again, this was a merger appraisal dispute. So it's litigation between the company and its shareholders, or in this case, former shareholders who have been merged out, have had their shares redeemed or canceled for consideration. And the issue is what is the fair value that should be applied to those shares. Um, what what the issue here that rose up to the Privy Council was whether Bermuda law includes the so-called shareholder rule, and that is that a company cannot, in the course of litigation between it and its shareholders or its former shareholders, withhold documents from those shareholders on the basis of legal advice privilege. There was no prior Bermuda authority on this issue, but English authority appeared to support the existence of the rule, subject, we have to say, and as the Privy Council highlighted, to some recent questioning in the last couple of years, and even in the last few months. Some trial judges who had cast some aspersions as to the proprietariness of this rule. The board examined both the history of legal professional privilege generally, and it looked at the shareholder rule more particularly, finding that the rule had its origin from analogies primarily with trustees and beneficiaries, so that there was a proprietary interest that a beneficiary had in legal advice that a trustee took, so that there shouldn't be an ability for the trustee to claim privilege against the beneficiary, or the idea that companies and their shareholders had a joint interest in the privileged documents, that it was almost a status based uh, privilege claim because the shareholders are effectively the company and have some interest in what the company does and the legal advice that the company is getting. After looking at those historical, after tracing the genesis of the rule, after tracing through the English authorities, they also looked at overseas authorities, which they noted, except for Cayman and Bermuda in particular, eh, other jurisdictions haven't really given a lot of credence to this rule. In particular, in Canada and Australia, it's been fairly rejected outright. And the board then rejected the existence of the rule in Bermuda law. And I think, very importantly, and this is why you've seen a lot of play from English law firms on this, the board made what's called a Willers and Joyce direction that the decision represented the law of England and Wales. So the board effectively said that the supposed basis for the rule in the historical authorities is inconsistent with the company having a separate legal personality from its shareholder, and nor are the companies and its shareholders' interests sufficiently aligned in the abstract to justify a purely status based joint interest privilege. So that was where they landed. The shareholder rule is no more, and it will not be applied going forward in England and Wales.
Yes, it's really interesting, isn't it? And I think there's quite a lot to unpack in that judgment. But there's a couple of points that I particularly found fascinating. Really, I mean, one point that really struck me was well, the way that the board, right at the outset of the judgment, goes back to first principles as to what the purpose of legal professional privilege is, because I think it's easy for us as lawyers to often really overlook what the purpose is and just assume that it's almost a rule of practice. But as the board made clear, it's essentially a fundamental human right and a fundamental condition on which the administration of justice rests. And it's interesting to remember that from a point of view of human rights law, Article 8, the right to family and private life, under the ECHR, does actually sort of protect or enhance the point of legal professional privilege. And I think one thing that really struck me as well was the discussion of the board when they go back to explain really what's the point of legal professional privilege. And I was glad to read the quote from Lord Scott in the Three Rivers case, where they go back to the public policy behind legal professional privilege, and they say, and this is a quote from Lord Scott in Three Rivers, when looking at the public interest, that they recognise that in order for the advice to bring about that desirable result, it is essential that the full and complete facts are placed before the lawyers who are to give it, and they recognise that unless the clients can be assured that what they tell their lawyers will not be disclosed by the lawyers without their consent, there'll be cases in which the requisite candor will be absent. And that, for me, that really shows that, I mean, really the whole point of the legal professional privilege is that, firstly, the clients feel able to tell everything so that the lawyer can properly represent the client in their cause, but also so that the courts, when administering justice, have all of the facts that they need before them to render a just result. Because without LPP, you find yourself in a position where um, people or clients, whether they people or companies, might be reluctant to tell everything, and you end up with results that are not just, or that are incomplete. And I think we need to bear that in mind when we consider even the context of this case, because, as I said at the beginning, it's often overlooked, in my opinion.
Yeah, I think it's a really good judgment for privilege issues generally, because
Yeah,
it goes back through those, as you say, those first principles, the historical development, why it's important, and then links it to, to this particular case, but is gives a really good overview of that. I think in privilege cases going forward, you're going to find some extracts here because it's just such a nice,
definitely.
cogent summary of those issues.
Yeah, yeah, that's right. Um, And I think the other thing that struck me, and you made this point already about the way that the board sort of traces back the genesis of the shareholder rule. It's interesting to see how it actually developed, and it seems to me that um, one could accuse Mr. Justice Chitty of being a little bit creative back in the 19th century. Because in essence, what appears to have happened is that you had the trustee rule, um, which, um, which, as we know, means that where there's an action between beneficiaries and trustees, the trustees can't claim privilege against their beneficiaries for materials which have been obtained at the beneficiary's expense. So, for example, advice that's obtained at the beneficiary's expense. You have that rule, and then what you have is Chitty. Taking not even that rule, but then what was an obiter comment in a case called the Mayor and Corporation of Bristol versus Cox, an obiter comment about that rule, and then elevating that to a situation dealing with shareholders and directors. And it's interesting that the trustee rule was now sort of used by analogy to reach to create the shareholder rule based on this proprietary justification. But actually, there was never any previous authority before this Gorard case, was the Chitty case is the Gorard and Edison Gow Bell case. There was never any previous authority for the shareholder rule at all. So it's interesting to trace it back and see, in a way, where things perhaps went, well, not went wrong, but where the it was almost at the very beginning they kind of went wrong.
It's funny, isn't it, how many of these type of things that we think of as these venerable old rules, when you're doing legal research and coming across them, if you actually do trace them back, and I feel like there's been a few of these in the last few years, either at the Supreme Court in the UK, at the Privy Council, or even in the Supreme Court of Canada, where when you actually trace it back, the foundations of some legal proposition that's kind of taken for granted for a long time is incredibly weak. And what happens is, as you say, someone pulls out some judge, as Chitty does here, pulls out some obiter comment and sticks it in a judgment. That judgment gets picked up. A textbook picks it up. That becomes an
Yeah,
authoritative text that just gets used. No one really goes beyond and looks past the footnote. When they then cite that text, the text gets cited in judgments. Those judgments get cited by other judgments, and you create this big superstructure, apparently supporting the existence of this rule,
yeah.
when the foundation was really nothing there at all.
No. And you're right. I mean, the point about the textbook's an interesting one because I think it seems that it was around 1943, wasn't it, that this went into one of the practice books, the equivalent of the White Book back in 1943, and it was stated to be a rule of practice essentially, or even a rule of law. But actually, as is often the case with these commentaries, the case authority that establishes the rule is a bit unclear, and it takes an appeal like this to trace it back and actually expose a very weak foundation. Um, because I suppose that the point that should be made is that you can't really draw the proprietary analogy between the trustee rule and the position of a shareholder and company.
Yeah,
Can you?
I think
Because
that's fundamentally what it is for me. Is the company
yeah,
is separate from its shareholders, and I think
yeah,
it speaks to, I think, a pre-modern, if I can use that terminology for, with apologies to Justice Chitty, and his compatriots in the 19th century and earlier. But the concept that a corporation or a company was simply a grouping of its shareholders,
yeah,
and a lot of that thinking is still kind of pervaded through the years and still kind of, I think, infects and animates certain principles that we have. But it really has been overtaken and should be overtaken, as the board did here with the modern concept that the company has a separate, independent legal personality from its shareholders.
yeah. But I suppose, I mean, even if you trace back the foundation of that principle, the Salmon and Salmon case, that was a late 19th century case. I think it's
Fair,
something like
fair.
1897, and then Chitty is 1888. So I mean, it's just, I don't quite know how there was this divergence, but you're right. There has been, people have latched on to this idea of how companies are constituted, and it's led to all these erroneous
Well,
situations.
it's one of the things that I think is actually quite interesting, and the board at one point talks about, at paragraphs 86 to 88. I'm just gonna read out a couple of these statements because I think it's interesting, and they're talking about the interests of the shareholders aligning with the company, and they make some comments that I think are interesting in a larger sense, where, they say at paragraph 86 that the interests of shareholders themselves are not always aligned. In reality, the
Agree.
interests of different classes of shareholders may diverge. Even within a single class, there may be real differences in outlook between them. They give an example, those who wish to maximize dividend returns and those who would prefer long-term capital growth. They're not, they make the point that shareholders are not a homogenous block with a single shared interest, which may
Yeah,
coincide with or diverge from the interests of the company. Uh, then they make a further point, which I think is interesting again, which is they say, yet further, even a solvent company has stakeholders other than just its shareholders, whose interests have to be taken account, such as its workforce. And the maintenance of solvency may depend upon keeping the company's principal providers of finance and working capital happy. What's interesting to me about those statements is, and look, I mean, some of these, employees, um, creditors, environmental considerations are codified in the English Companies Act when it talks about directors' fiduciary duties. But in jurisdictions where those duties are not codified, it's almost said kind of glibly that the interests of the company, when the directors are considering the best interests of the company, they should be thinking about the shareholders as a whole. And then you have the Privy Council here talking about how the shareholders don't necessarily have the same interests, and there are other
No.
interests that are important to the company. So
Yeah.
I think in outside, obviously, not super applicable in England because of the codification of the fiduciary duties, it's already in the statute, those interests that you have to take into account even in a solvent situation. But I think in jurisdictions like the Cayman Islands, other offshore jurisdictions where the fiduciary duties haven't been codified and it's still common law, I think those are some interesting comments that could be used to put a bit more of a gloss as to what the interests of the company actually are that directors may have to
Yeah.
consider in their fiduciary duty. That's obviously way
Yeah.
outside the four corners of this judgment, but, the next fiduciary duty case I have, maybe I'm thinking about some of those comments if I'm someone outside of the shareholders, or if I'm dissatisfied with the decision that's been made by the directors purportedly in the best interest of the members as a whole.
Yeah, no, absolutely. I mean, I suppose it's the reality is that the authority at this level, even when you have in a comment that isn't strictly part of the decision is made, I mean, it's going to be used, and it's going to be there might be potentially some interesting points that can be made from it.
Well,
Um,
it's how we got the shareholder rule, isn't it?
there you go. So, but I suppose when you're just sort of thinking on that theme, just thinking about the impact of this judgment, it takes me on to the Willers and Joyce direction, that obviously was made, and everyone will know what a Willers and Joyce direction is. It's based on the case of Willers, the Supreme Court case, Willers and Joyce, which I think was it 2018? It was relatively, or 2016, or sometime
I think
in
it
the
was
last
2016, yeah.
15
Yeah.
years or something, um, where the UK Supreme Court said that a when there is a decision of the JCPC that's made on an issue that is in conflict with a previous decision of the UK Supreme Court and I think the Court of Appeal, the UK Supreme Court, sorry, the board can make it the Willers and Joyce direction such that the judgment of the board applies in England and Wales. And it's interesting that that's been made here. I mean, we can see why it's been made. Firstly, perhaps because of the comprehensive analysis that's conducted by the board and the rejection of the shareholder rule for good reason. And but second, the constitution of the board was obviously it was of UK Supreme Court judges, and that's the rationale really behind, in part, the Willers and Joyce rule, that because the justices or because the judges are invariably the JCPC judges are invariably Supreme Court judges. It's sort of safe to be able to make this direction. But one point that kind of that arose for me when I was considering was the fact that the board in the last year or so has started appointing judges that aren't UK
Yeah.
Supreme Court judges to sit on certain appeals. And an example of that is the Anglin case that we'll discuss in a moment, where the former Chief Justice of the Eastern Caribbean Supreme Court, Dame Pereira, was sitting. And I just wonder, I mean, this is just me wondering out loud, but I just wonder whether the court, the board would be less willing to make a Willers and Joyce direction in circumstances where the constitution of that panel wasn't exclusively Supreme Court justices.
I think
I don't know. I mean, it would
yeah,
be.
I think that's a really
I
interesting
bet they
point.
wouldn't.
And
Yeah. I mean,
what here's another wrinkle on that. What if you have one of these non-Supreme Court justices sitting, and you have a split decision with
right.
but it's two Supreme Court justices, and then it's not appropriate to call them a guest judge, but they're a Privy
Yeah.
Council. They're a non Supreme Court justice. is on the panel, and they're in the majority. Will they make a Willers and Joyce direction in that circumstance
Yeah.
when the
Yeah,
members
it's
of the Supreme
interesting,
Court
isn't
were
it?
actually split? I think that's a really interesting point. I think the Willers and Joyce direction was an easy one here as well, though, because so much of the
Yeah.
law was English law that they were dealing with. It wasn't a situation where they said there was no Bermuda authority. If it was something where you were looking at Bermuda authority, there were a lot of Bermuda cases, and that's what the arguments were about, and that's what the parties were relying on. It might be a little bit more palatable to limit it to Bermuda, but I think it was an easy
Yeah.
decision here to make a Willers and Joyce direction because not only because so much of the material and the authorities relied on to support the existence of the shareholder rule in Bermuda was English authority, but also because the issue was percolating up through the English courts as well.
That's right, isn't it? And that's an important point to make, that I think there was a high court ruling in recent, I don't know how long ago, recent years, last couple of years, where the judge gave permission to appeal and suggested that there should
The
be a
leapfrog,
leapfrog to the Supreme Court, but that was refused.
primarily on the
And
basis,
it's
I
not,
think, because this case was
yeah,
pending at the Privy Council.
yeah, exactly, exactly. So yeah, um,
Yeah.
interesting.
So
It is interesting.
the last point I just want to make about Jardine, and then let's go on to the interesting constitutional case, is that the shareholder rule, in my experience, anyway, is very frequently. It's not the shareholder rule in this context, but it's deployed in disputes between general partners and limited partners in a limited partnership, because limited partnerships are very popular corporate vehicles to use in offshore jurisdictions. And I've been in a couple of very heated disputes about document disclosure involving disputes between GPs and LPs, and met with courses, howls that how dare the GP try to withhold any documents on the basis of privilege.
Yeah,
There's there's been some talk, and there's been some articles and commentary that have come out from some law firms talking about whether that rule about the GP not being able uh, to assert privilege against LPs in these similar circumstances will survive this decision. My view is that, at least my preliminary view, is that the circumstances are actually quite different. With a limited
yeah,
partnership, the GP and the LP are technically partners, depending on the exact statute that they're operating under and in which jurisdiction. The GP is sometimes expressly made a trustee for the limited
yes,
partners. So there's a much closer interest there than in the company and shareholder world. And of course, in many
yeah,
cases, again, in many of these offshore jurisdictions, a limited partnership is not a separate legal entity. So it's a
yeah,
true partnership. So I think, but I think you will see the argument made. So watch this space because I think people will try to make that argument, and it will be a fight that we will see, as I say, percolate up through some offshore courts and Cayman and Bermuda, BVI, and others.
absolutely. And I think I agree with you. I agree with your take on it, that um, I'm not convinced that this judgment will lead to um, we'll have the same result in relation to partnerships. And part of the reason for that is that the what the judgment makes clear to me is that what one needs to look at really is whether there is a joint interest that privilege should be protecting, rather than looking at the label of whether you are a shareholder, company dispute, or a partnership dispute, or a trustee dispute. Um, there may be times where joint interest privilege does apply in the shareholder company context. Probably very unlikely in light of the judgment. But what we need to look at is the facts, and it's very fact specific, and that's what the court, I think, makes clear, is that it isn't simply a question of labels. And so it would be a misguided argument, I think, to make, to suggest, well, because it applies in the case of companies and shareholders, it must apply in the case of partnerships. It simply isn't that straightforward.
All right. Well, look, that's Jardine. Let's move on for a real shift of gears here from a commercial dispute dealing with important privilege issues to a constitutional, dare I say, division of powers type dispute. Anglin and the governor of the Cayman Islands.
That's right. Um, yeah, Anglin, the governor of the Cayman Islands, was heard earlier this year with judgment delivered in around July. As Mark, you've said, it's a constitutional case, and it's an interesting and important case because um, it is, as far as I'm aware, and I did check this in quite a lot of detail in the preparation of the case. It's the first case that really probes the legislative relationship between the UK and its overseas territories. It's a Cayman Islands case, but it has wider application than that. Um, and in particular, what it looks at is when can a British overseas territories governor pass a law um, that is basically a law that's been rejected by the local legislature, so contrary to the will of the people in the territory, essentially. Um, the background to Anglin, just in very brief brief summary, is that the governor used his reserve power to pass a Civil Partnership Act. That Civil Partnership Act had been rejected by the Cayman Parliament, and so the question was whether the governor could legitimately, under the constitution, use uh, his reserve legislative powers to pass an act in these circumstances. Um, before I'll give a bit more details as to what happened in terms of the facts, but it's worth just starting with a review of what the actual structure is of the British Overseas Territories legislatures, because they aren't the same as just the standard Westminster model. They obviously have similarities, and there is a link, an actual literal link to Westminster, but they are in other ways very different. It's perhaps well known that the majority of the British Overseas Territories, so including Cayman, including the BVI, Bermuda, these are all self-governed democracies with elected governments and legislatures that have responsibility for domestic policy and law. But the United Kingdom, as the authority, the crown that is ultimately in control of the territory, has responsibility for external matters, which include things like defence and foreign relations. And generally, the when the UK wants to act, it acts through its governor, who is a person appointed by His Majesty, who is based in the territory. And so it's fairly well known that that's the basic relationship. But what is less well known, perhaps, is when can the UK intervene to make a law in a territory where the democratic process in that territory has chosen not to make that law. Um, and there are basically two ways that this can happen. The first way, which applies to all British overseas territories, is through what they call an order in council that is passed in Westminster. Um, uh, Basically, an order in council is passed, and that creates a law in the local territory. This is a very broad, practically unlimited lawmaking power, a plenary power, as it was described in the case of Banku, which is another constitutional case from, I think, back in 2018. Um, but essentially, this is the sledgehammer that the UK has when it wants to pass a law in a territory. It passes an order in council in the UK, and then that has effect in the territory. But obviously, the problem with that approach is, or it might be said, is that it it doesn't have much respect at all for the will of the local people. And so there's another way which is perhaps considered to be more aligned with local politics and local wishes, and that's where the governor, who is the individual appointed in the territory, passes a law. But actually, the reality is that law is still passed by the governor on the instruction of the UK. And so when can this happen? When can the governor pass a law? Well, the governor can pass a law in the Cayman Islands where two conditions are present. The first is that the local legislature won't pass the law, or that appears that the local legislature won't pass the law. And the second is that the law is one that is necessary or desirable with respect to or in the interests of any matter for which the governor is responsible under the Constitution. And the matters that the governor is responsible for under the Constitution, in the Cayman Islands Constitution, that's Section 55. And this goes back to these sort of external responsibilities, which relate to defense, um, external affairs, and then certain other internal matters like the appointment of public officials. And so that's the basis in which this case arose. What essentially happened then was, there was another case called Day and Bush. It was another Privy Council case, actually, which concerned two women in the Cayman Islands who approached the registrar, the marriage registrar. They asked for a marriage license. It was denied to them. They then went through the courts, challenging the denial of the marriage license on the basis that they were that this was a breach of their constitutional rights, including their right to a private and family life, and indeed the right to marriage. The long and the short of it is we don't need to go into that case in detail, but basically what happened was that even though they were unsuccessful in establishing that the Cayman Constitution did confer a right to marry, the Cayman Islands Court of Appeal, when hearing the Day and Bush case, held that whilst there was no right to marry for opposite sex couples, there still had to be a legal framework permitting some form of legal protection that's functionally equivalent to marriage. And otherwise, if there wasn't, there would be a breach of the right to private family life protected by Section 9 of the Cayman Constitution or Article 8 of the ECHR. And so essentially the Court of Appeal in that case found that there had to be some law in place. Otherwise, Cayman and indeed the UK were in breach of those provisions. And importantly, what the Court of Appeal in Day and Bush also said was that if the Legislative Assembly in Cayman, which is now the Cayman Parliament, but if the Legislative Assembly didn't pass such a law to create a law that was functionally equivalent to marriage, then the UK government should step in to bring that state of affairs to an end. So essentially, this is before we even get to the facts of Anglin. What had happened was the UK was in a very difficult position because it was in breach of the ECHR by virtue of the state of the law in the Cayman Islands. And it was left with asking the Cayman Islands legislature to pass a law to remedy that breach. And that brings us to the facts of Anglin, and I'll be as brief as I can in relation to that. But in essence, there was a bill that was put forward in the Cayman legislature. It was debated for 2 days, and then it was rejected. And so what you had here was a situation where the democratic process in Cayman had rejected what the Court of Appeal had demanded. And this was a further awkward position for the UK because obviously the UK wants to respect local democracy in the territories, but at the same time, it has to abide by the ECHR. And so at this point, the UK had options of either passing an order in council, which is what I described as the nuclear method earlier, or going via the governor, which is a slightly more it's on the face of it, the optics are that it's much more of a local process. And they went through the governor. And the case in Anglin was a judicial review challenging that decision on the basis that the governor could not pass a law bringing into effect a civil partnership act for same-sex individuals, because it was not a matter that fell within the governor's special responsibilities. importantly, it wasn't a matter that fell within external affairs. And so that is, in quite a long nutshell, a large nutshell, what the case was about. And so let me just run through, in essence, what the two main arguments were. The first was that there was no power for the governor to legislate in respect of um, external. Well, there was no power to bring this law into being in relation using this power, because um, bringing a domestic law dealing with the civil partnerships was not a matter of international obligation. It isn't an external affair. Um, because matters in relation to local civil partnership laws are strictly within the domestic sphere. They aren't external affairs. That was the first argument. And that came down to the meaning of external affairs. And the board, in essence, rejected that argument and said, no, external affairs have to be construed very broadly. They include relationships between the Cayman Islands and the UK, but also relationships with other countries and indeed with international organizations. When read in the context of the Constitution, the board found that external affairs was so wide that it should include compliance with international obligations. And so that allowed the governor to use his reserved power based on external affairs to bring the Cayman law into compliance with the ECHR. The second argument, which is a slightly more perhaps interesting and nuanced argument, is in relation to dualism.
Yeah.
And as you know, the principle of the dualist principle of international law is that while the executive agrees treaties like the ECHR, it is for the legislature to implement those treaties into domestic law, because there's a separation of powers between the executive and the legislature. And the problem that was identified by the appellant in Anglin was that what you had here is essentially the governor who is responsible for the business of the government with respect to external affairs, um, using his reserve power to bring a treaty in to implement it into domestic law, which is not the business of the government, but the business of the legislature. And so there was the appellant submitted that was a breach of the dualist principle, or it was inconsistent with the dualist principle. Um, and the board also rejected that argument on the basis that whilst that might be the case generally, Section 81, which is the reserve power, um, uh, the legislative power for the reserve powers, expressly applies to external affairs and was a legislative power, and so was a fulfillment of the dualist principle. So that's probably a bit of a long explanation of it all, but that is essentially where it comes to.
Well, it has a long genesis. It's difficult to explain the background without having to go
Yeah,
through the Day and Bush uh, reasoning, because that's where
yeah, it is.
it all comes from, right? It's the Court of Appeal and the Privy Council in those cases, kind of pointing out that there's a problem here with international obligations. I think it's unfortunate in some ways that this the pure constitutional issue came through the courts on an issue that of real fundamental human rights.
Yeah,
Because I think it changed, I think, a lot of the public debate and the dynamic of that public debate around the issue. And it makes it, ultimately, I think we can all agree, or not all of us, obviously, but I think, most people would agree that the ultimate result here of that the Civil Partnership Act exists in the Cayman Islands, and that same-sex couples have the ability to have all the same rights and benefits and privileges as opposite-sex couples do in that type of a partnership, and have the equivalent, even if not the same label as marriage, is good and is a good result. But I think that to get there on this case, I've had problems with the way that the courts have dealt with it on this matter all the way up through. I mean, I think on the board's analysis, you can turn anything into external relations, and I think the board
Very
glosses over
confident.
that point in the judgment and doesn't really grapple with it except kind of to toss it away.
Yeah.
If a future and I think it's interesting that the Cayman Islands government, obviously the attorney general, defended this law at certain stages. I don't know if they were actually a party at the Privy Council. You can correct me about that one if I'm
Yeah.
wrong or not. But if a future UK government agrees to something like a global minimum tax, a global minimum corporate tax rate, and then instructs its local governors in Bermuda, BVI, Cayman to either get that passed in the legislature or to use their reserve powers under the external affairs basis. Um, eh, that's something that is not going to be very popular. But again, under the same
No.
rubric, I think becomes external affairs. And I think you can make
Well, that
any domestic issue external affairs by just saying, well, I have a treaty obligation. The mothership
well,
has a
that's right.
treaty obligation. The mothership has, as you say, that the way that they defined external affairs was more than just, treaties in the sense of, the Vienna Convention on the Law of Treaties. It's really any kind of international obligation. So I think it's very, very broad and really opens the door for results that, practically overseas territories may not like.
No, that's right. And I think and it's yeah, the analysis that you put forward is right. That I mean, it's such a the 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 definition of external affairs being so broad means that it becomes quite easy to link any domestic law to an external affair issue. And so if that's the case, then you can foresee future disagreements being um, put through the governor's reserve power route by reference to external affairs, even though it's actually a fairly tenuous reference. And that is, I think, troubling um, the for the local electorate and for the people who live in the territories who may be unsure about whether they want to be part of the UK. And I think what it also does for me, and it picks up, picking up on the point that you've made, is it does bring into question um, the the question of the sovereignty of the Cayman Parliament. And whilst we know that obviously the Cayman Parliament isn't sovereign because it is beholden to the UK for the reasons that I've identified, because the UK can impose law through those two means. I think probably from a political perspective, many citizens of the overseas territories are um, less clear about that relationship. And it may come as a bit of an unpleasant surprise to realize that actually the UK does have these really unlimited powers to legislate on behalf of the territories. And whilst obviously that is all part of the constitutional settlement, and whilst that is something that was agreed to by the Cayman people, and I should emphasize that it's not that, whilst it may come as a
So the
surprise, it
Constitution
shouldn't be.
passed in a referendum.
Exactly. Exactly. I mean, the reality is that this is something that was agreed to, but nevertheless, it's so rare that the UK does intervene on these kind of contentious social matters that it's the sort of thing that may remind people of the imbalance of power and spark debates about whether they want to be dependent on the UK um, for any longer.
Yeah, I think the
'Cause I think,
democratic I think
yeah,
the democratic legitimacy point is important here, because, if the of course, yes, the UK could always have just exercised its powers to do this in an order in council, which they did,
yeah,
in many territories with regard to things like the death penalty,
yeah.
and outline, laws that outlawed, homosexual acts just generally. So, but that's the point though, is that here, the UK could sit back and say, "Well, we exercise powers through your own constitution." And it puts this veneer of democratic legitimacy over it, when, as you say, the local legislature considered the issue and rejected it. So uh, sometimes you should have to do, if you're the UK, do what you might think is uncomfortable when you want to
Yeah.
impose that legal reform. You're saying it's for your external obligation. Well, you take action in a way that actually is uncomfortable, I think, then to do that, and do the uncomfortable thing, because I think that it puts a veneer of democratic legitimacy on this when it's exercised in this way, through the governor, through the Constitution, as they say. The Constitution was approved by the public in a referendum, in the voting public at the time in 2008 or 2009, to approve that Constitution that had that. Interestingly, um, they were very close in the negotiations to the UK agreeing to remove
Yeah.
Section 81 when this issue came up. The day in Bush question arose, and then the issue that they thought that the governor may have to exercise those reserve powers, and the UK then refused to entertain removing Section 81 from the Cayman Constitution in the last round of constitutional negotiations that led to some amendments.
Yeah. No, it's interesting. I think you're right. One of the arguments that the appellant made in Anglin was that actually the UK could have used the ordering council method. It was never kind of disputed that that was one of the ways this law could be passed. But as you say, it's by going through the governor, I think from the perspective of the Cayman people, it makes it look like it's something that's coming from Cayman rather
Mhm.
than from the UK, because the governor is associated with the Cayman
Yeah.
politicians and lived in the Cayman Islands and is seen it out and about,
Yeah, he's a member of the
kissing
Cayman
babies and
community,
shaking
right? He's
hands
there
and
cutting
such, right? Yeah,
ribbons and
exactly.
hosting tea parties. Yeah.
But
Yeah.
exactly. So it's seen as something that is done through the as another part of the Cayman legislature, as it were,
Yeah.
or the power
Yeah.
makers. But the reality is, it isn't, and that is interesting. And I think you're right. It is a little bit misleading from a point of democracy and accountability. As I said before, if perhaps the Cayman people were more, or indeed generally British overseas territory people were more aware of this, they might be less happy with how it's been done. Um, I mean, the point that arises from that for me as well is that one of the things that the board said in concluding that the governor was acting within his powers in doing this was that there are safeguards in the Section 81 reserved power route. And the safeguard, in essence, is that there has to be consultation with the premier of the Cayman Islands before this law can be passed, before the Secretary of State can instruct the governor to pass it. But the difficulty with that is, I mean, what is that? What does that actually mean? I mean, yes, there could be a consultation, but it could just be paying lip service to the idea of, oh, we'll listen to your objection, we're against you, and off we go.
Yeah.
So I think these safeguards are illusory, really. Um,
Yeah, and I mean, I
yeah,
think that's right. That's probably the level of consultation that occurred here. They walk
yeah,
into the premier's office. The governor's entourage walks into the premier's office and says, "You guys didn't pass it. I'm thinking about passing it." The premier says, "Well, we didn't pass it." And they say, "Well, we have a court of appeal. We have the Privy
exactly.
Council telling us one thing. Um, I'm getting
Yeah,
instructions from Secretary of State in in Westminster.
yeah,
So here we go. It's happening. But I
yeah,
don't think it'll be the last time that the last word that we get on Section 81 and the exercise of these powers going forward.
yeah. No, I agree. I agree.
Okay,
So,
Rupert, that's
yes,
Anglin and the governor of the Cayman Islands, which brings us to what we wanted to talk about today. So thanks everyone for listening or watching. Wherever you are, you can check us out on YouTube or wherever you listen to podcasts. You can visit jcpcwatch.com for the regular site, which has links to the videos, the podcasts, and weekly updates and other materials and insights on the Privy Council. So thank you very much, and we will see you again next time.
see you next time.